On the News Channel 5 network, this is OpenLine.
Well, good evening and welcome into OpenLine. I'm Chuck Long and glad to be along with you for the next hour. Extra excited about tonight. We are going to be talking to the expert. Ask an Expert tonight is Ask the Attorney, and the attorney that we have on the show tonight is Kevin Kennedy from the Kennedy Law Firm. And if you've ever seen the show when Kevin's on, you know that our phones light up like crazy because not only are there a lot of questions out there, I know that you have probably legal questions, what to do, what's the right thing to do, not to do. Kevin not only has the answers, but he's got the experience. He's got a lot of followers out there that love it when he's on the show because he gives them the kind of information that you can use. So we're going to welcome Kevin right now. Kevin, great to see you as always.
It's always fun to be with you.
I love it when you're here.
I love to come and share with you because you're so, he is so vivacious. Even when we're on the set and when we're off the set, this is a guy that's just full of fun. People love him and I do too, and he's just great.
Well, I appreciate that very much. But as I said, this is all about you this hour. Well, it's about you sharing your wisdom, sharing your knowledge.
Come on. You know, when we have this opportunity to get to talk to everyone, I do like to share because we can make a difference in your life. So you can take some notes, get ready to call your children and tell them, you know, I just saw this could affect you. And you got neighbors, co-workers that are going through a problem. Feel free to call in. So many people say, I wanted to call, but I didn't want to sound really crazy. I said, no one is crazy. Go ahead and call.
That's right. Now, we're going to be taking the calls shortly. If you're just tuning in, the number's on your screen. 737-7587 is the number to call. And, you know, we often say, sometimes you're sitting out there and you're thinking, well, I don't know if that's a good question or not. But a lot of times those questions that you have, other people have as well. And so you ask the question, you answer, and it helps a whole lot of people out there.
So much of the law still gets down to plain common sense. Many times you say, I know the answer, but even like myself, you know, I have the most experience of all the lawyers at my office. I like to hear their opinion because even as we talk about it, that makes sense, and you like to talk about it because it helps you understand. And then a little advice goes a long way. It'll give you some peace in the night. Those guys say, man, I was tossing and turning all night long. I said, well, why didn't you just call? You should call. And most lawyers talk to you a free initial consultation, and sometimes getting second opinions goes a long, long way. So tonight, we're glad for you to have your questions, and we'll share with you what we can.
Absolutely. We're already going to the phones right now. So, caller, you're on the line with us. Good evening, and who are we talking to?
This is Marilyn.
Marilyn, we're glad that you called in this evening. And do you have a question or a comment for Kevin Kennedy?
I have a question.
All righty.
If you have a spouse that had estate property left to them before you married them, and if you're going to get a divorce, are you, as a spouse, entitled to any profits or anything from that estate property or not? Because it always states estate once is you know, claimed estate.
Here's the deal on that. As a general rule, inherited property would be separate property during a marriage. However, a very skilled lawyer and a very creative lawyer, for instance, if you were given a home and we lived there over a period of time, that lawyer would argue that all the enhanced value you may have gotten when it was worth $100,000, but you worked on it, you cleaned on it, you painted on it, you upgraded cabinets, and so the value of the home now is $200,000. Then you would argue that 50% of that increased $100,000 belongs to the other spouse. And so we do that. That's the gray areas. There's always gray areas. Great lawyers create gray areas, and great lawyers dance in gray areas. And they say, well, what's the law? The law is the facts, and then there's the law, and how you apply that gets the interpretation. Those guys with the greatest argument, I've actually been in court and watched these lawyers argue points like this, and you say, that guy's right. Then the other lawyer gets up and he puts on an equally good argument, and you say, that guy's right. Well, how does the judge make a decision? And most of those lawyers are studying the judges, and they know them. If you've heard a judge rule and rule and rule on certain things, you know what he likes. And so there's the gray areas. But no, absolutely. And if you got a lawyer that didn't sing the song that you like, I'd entertain talking to another lawyer and see if he could develop a theory that would be in your best interest.
Okay, well, Marilyn, we appreciate you calling in this evening, and great advice for her, you know, and again, for a lot of people out there watching, I know that helps you as well. Now,
you know, I want to say this, Chuck, it reminds me, I was in the class and I heard my teacher, he was a court of appeals, he said, never say never. And he used to always say, it ain't necessarily so. So he's the master of evidence. And by the way, I graduated #1 in my class on that field of evidence. So what did I take away? Never say never. And he said, it ain't necessarily so. Meaning if the law said this, it ain't necessarily so. The facts said this, and I've been practicing now in excess of 34 years, and I say that's a good thing. And lots of times when you have a car wreck, we had this happen today, the kid jumped out and he said, I'm so sorry, it's all my fault. The insurance companies are telling you, don't go admit that it's your fault. Because, and the other thing that I'm seeing a mass run on, I want to tell you, we get an insurance policy for a car, and now the exclusion package that comes, Chuck, is 4 times bigger than the policy. So there's so many exclusions. Are you really covered? And of course, they're going to dance in the gray areas.
Well, and as you know, we've seen many, many times, people get in an accident and they think they need to say something, or they need to say this or that, and then they don't realize, just don't say anything. I mean, seriously,
absolutely.
Hold on.
You know that old saying, it says, loose lips sink ships. They say 90% of the people in the penitentiary are there because they talked. So, you know, I'm pretty skilled, but I want to hire me a lawyer, and I want to hire Chuck a lawyer, and we're going to probably get through this because we're not going to make foolish mistakes.
There you go. All right, we're going back to the lines right now. Charles is on the line with us. Charles, we're glad that you called in this evening. Do you have a question or a comment for Kevin?
Question.
Okay. Go ahead.
They say the government is judgment proof, and I found that out when I sued a state college. That's all the defense attorney said, and he won. But last year, I sued Metro Housing for inhospitable conditions, and the lawyer had to make a defense. You couldn't just say the government is judgment proof. What is the criteria to determine whether or not the government agencies can be taken to court and held liable for legal action?
Yes. Well, the truth is, people sue agencies all the time. You have to figure out, we're under the common law, and the common law came from England and said you can't sue the king. So there's going to be a lot of immunity against judges or DAs, but they do have many cases where they sue Metro government and they get a judgment. Well, guess what? They are not judgment proof, and they can be collected on. The vast majority, and the problem when you're suing these governmental entities, if you get it past the Governmental Tort Liability Act, if you get past that, they keep appealing. And in fact, we had a big win within the last month, and the case went all the way to the Supreme Court, 8.5 years. Well, and I'm even looking at, with all the lawyers that worked on this, I said, guys, really, we're pouring a lot of money in this. If we don't win, you know, we've eaten a lot of this. And they said, we're just going to keep pressing. I said, can we win? And it's up to interpretation. You go to the Court of Appeals, you go to the trial court, you go back. And so it's up to interpretation. But we did win that, and it was persistent. So, again, if you get a judgment against them, and our case was against a governmental agency, they did, and they ran out of room. They ran out at the Supreme Court. It's over, so they paid us.
Wow. So, Charles, we appreciate you calling in, and that was a great question. Helps a lot of folks out there. So we're going right back to the lines, though. A lot of you getting on the line. If you do have a question or a comment, make sure you get on the line with us, and we'll get to those questions just as soon as possible. Right now, we're going to Gwendolyn. Gwendolyn, we're glad that you called in this evening, and do you have a question or a comment for Kevin?
I have a question.
All right, hit it.
Okay, the question is, okay, my father, who is married, he passed like 20 years ago.
All right.
Okay, now my mother was my father's mistress.
Okay.
But my stepmother and my father, they raised my sister and I.
Okay.
So my stepmother, she passed this past February. And when she died, she left a will leaving the house to her niece.
All right.
Now my question is, my father passed without a will.
Mm-hmm.
So does the house automatically go to her because my father died, or
does the house go to my sister and I, because we are her biological family?
Okay, this is the great question, and I thank you for it because it affects so many people. The first thing we need to look at is the deed. Most deeds are in a husband and a wife's name. That's called tenants by the entirety. When I pass away, it automatically goes to her. But if he just had it in his name only, then when he passes, it would go to his heirs at law if he had no will. So that's the first thing that needs to look at. So if he had it with this woman and they were married, and when he died, it automatically, by operation of law, goes to her. And you know, a lot of men have part of their property in their wives' names, tenants by the entire, and then they have other property in their name only. Why? They don't have to have their wife's signature. They can buy and sell and move right on. In the state of Tennessee, you have to have one residence would be considered the husband and wife's, and that takes care of what's known as a homestead exemption.
Okay, so again, Gwendolyn, great question, and we're glad that you called in.
Thank you.
About that, absolutely. So we're going back to the lines. Like I said, they get very busy very quickly. So if you do have that question or comment, just give us a call, and we'll get those questions in line as quickly as possible. 737-7587. Let's go to Raymond right now. Raymond, thanks for your patience, and do you have a question or a comment for Kevin?
Yeah, it's about a will, too.
Okay, hit it.
A friend of mine's mother and father passed away, and they know they had a will, but they can't find it. And the lawyer that they think wrote up the will, they think there might be a copy, but they're trying to say that they won't recognize a copy. Mm-hmm. Is this true?
In the state of Tennessee, you have to have that original will. There is a presumption that if there's no will found, that the person could actually just tear up the will. And you know, some people say, you know, I love you so much, let's go do my will. And they say, I'm going to leave everything to you when I die. Then they walk right out of the law office, they tear up that will, and so you've got nothing. And they could come in and write another will. And some of the really wealthy people that I've represented over the years would get mad at their children, and they'd come in and write them out. Then they make up and they'd write them back in. And so you really need the original. You got to keep up with it, and then the court would have to prove that. So there is a good, but again, what did I say earlier? Never say never. And a creative lawyer, this may be the best evidence that we have, and I won't give up on that either side, but that's what the law would say.
Well, and I've got a question on that. I had someone ask me this the other day, and I said, I'm going to see Kevin this week, so I wanted to ask, what if someone, their mother or their father, they have a written will, they've never gone to the attorney and gotten this, you know, official will, but they've got that written will, something happens to them, can the child take that will to the lawyer and say, this was mine?
Yes. In Tennessee, you can have a holographic will. What that means is it has to be written in the handwriting of the testator, and it has to be signed. So if we got jammed in here and it's all over, I could pull out this yellow piece of paper and I could write that and sign it, and it would, and I'd say at the beginning, I revoke all other wills. And so yes, when there is a will, there is a way.
There you go. All right, we've got more great advice from Kevin, but we are going to be taking a break. When we come back, more questions from you on Open Line, so come back with us.